It's important to note that employers of less than 15 um, may still be covered by the Immigration Reform Control Act's anti-discrimination provisions. So employers with 4 to 14 employees are prohibited from discriminating on the basis of national origin. Language proficiency is the issue, right? So making sure that someone is proficient in a language is a bona fide occupational qualification. That's perfectly fine. But you still are not allowed to discriminate based on national origin, accents, and things like that as long as they're proficient in the language. Employers with 4 or more employees may not discriminate on the basis of citizenship. So the Immigration Reform Control Act um, um, sort of fills in some gaps where Title VII leaves somewhat of a hole, if you will. It's probably the best way for me to think about saying that. So what it, anything 4 or more, you can't discriminate based on citizenship. 4 to 14, you're prohibited from discriminating on the basis of national origin. With language proficiency as an appropriate BFOQ, so you may not be actionable under Title VII, but you are actionable under the IRCA. In terms of undocumented workers, they tend to comprise about 4 to 5% of the year's workforce. And before people start clutching their pearls and being worried about it, we know that these undocumented workers aren't moving into CEO positions and making millions of dollars and sort of influencing and taking over the world, and for all intents and purposes. They are engaged usually in a lot of manual labor, working in plants, working in meatpacking plants, working in manufacturing environments, working in migrant labor in terms of agriculture. This is where undocumented workers are working, and largely because, calling it what it is, people aren't willing to pay, $5 for an apple. People aren't willing to do that. And because people aren't willing to pay top dollar for apples, people who own apple orchards, for example, cannot afford to pay $12 an hour or $15 an hour for somebody to pick apples. And so undocumented workers are willing to work hard to do the work for, to be paid off the books and to do that, um, uh, to do that without worrying about, having documentation to do that. And this is a dilemma for a lot of employers. On the one hand, they recognize that they're doing something that's against the law, that they're engaging in hiring undocumented workers, but those undocumented workers are not taking away jobs that people necessarily want. They're doing the jobs that nobody wants. And the wording on the IRCA, the Immigration Control Reform Control laws, says we don't we're not allowed to knowingly hire or recruit somebody that we know is not authorized to work in the United States. So that's why we're required to use the I-9 form. And the Department of Homeland Security ruled that employers must terminate all no-match workers. No-match workers are workers who use false Social Security numbers. So if you have to terminate them if you find out, but employers are not obligated to do a search about whether or not the Social Security number is actually fake. That is not the responsibility of the employer. We have to make we are taking at face value that the I-9 form has the information, and that if they present me with information that proves that they're a citizen, then I'm going to take it at its face value, that it's true and faithful. If I know that it's illegal, that's an entirely different story. But if I don't know it's illegal, then there's not much I can do about it. So, but if you find out that there is a no-match worker, that's an entirely different story too. It's, again, we're not obligated to go after it, but we are obligated to terminate somebody who does not necessarily have a Social Security number that we know of. In terms of the issues with undocumented workers, the Obama administration tried to focus on what they could do to manage the situations for the employers. They reviewed, rescinded the no-match rule, and the Social Security Administration basically now issues notices to employers when they know of employees whose Social Security numbers just don't match, right? So Social Security will tell them. So the employer is not obligated to do the digging. The Social Security Administration will tell them that. ICE, or Immigration and Customs Enforcement, will send notice of inspection to employers to let them know when they're going to be doing a raid of undocumented workers. And on the one hand, you might say, well, why bother? Because if you give them notice that you're coming in tomorrow, you're just going to tell your undocumented workers to not show up to work. So it seems sort of an interesting approach to things, but nonetheless, that is, ICE is really about trying to get undocumented workers back to their home countries. That's their job, but it doesn't overlap with the work that we do on discrimination issues, because even undocumented workers can be found to be victims of discrimination. But the challenge, of course, then is, is somebody going to call ICE because an undocumented worker is making a complaint? Right? In terms of IRCA enforcement, employers are subjected to random compliance inspection. And in that, you just never know when somebody's going to come in and do an audit of your books to know who's documented, who's undocumented, etc. There's been a dramatic increase in enforcement cases against individuals and non-compliant companies. And perhaps this is an artifact of the Trump administration. It's hard to know whether that's going to continue under the Biden administration and how we're going to manage that. And so there's going to be obviously this is a big, huge pushing point between both sides, between the how to handle the documented workers and how to deal with um, um, undocumented workers, how to get them maybe in a pipeline to get citizenship in some way, and remove the incentive for them to come as undocumented. There's a lot of complications in immigration policy. It's not an easy one to reconcile. As I stated earlier, undocumented status does not necessarily mean that they have no recourse regarding discrimination. The EEOC's position says even if they're undocumented, that doesn't justify workplace discrimination. And so it does make sure that undocumented workers um, at least will be found to be remedied at some level. They're not going to get back pay. They're not going to get reinstatement, but there may be there's other recourse to address the issue simply because they're undocumented. The employer's liability for remedies promotes the goal of deterring unlawful discrimination. You're going to pay a penalty if you're not addressing this issue, and if you're found to be guilty of it, that's a big problem. The Fair Labor Standards Act, that is administered through the Department of Labor, protects undocumented workers from some abuses, but not involving future pay. So you can't get your future pay, under the Fair Labor Standards Act because you're not eligible to be working there in the first place. So it's a complicated situation. And so what ends up happening is our undocumented workers, when they're being discriminated against, often don't say anything because they would lose their job otherwise. Section 1981 talks about an alternate basis for what we call national origin or citizenship discrimination. The law applies to identifiable classes of people who are subject to intentional discrimination solely because of their ancestry or ethnic characteristics. Basically, it's ethnic characteristics or race. It gets at the same basic ideas. And a good case is St. Francis College versus Al-Khazraji. Now, this is interpreted fairly narrow as later cases came, but fundamentally, we want to make sure that we are not using ancestry, ethnic characteristics, race when we're making hiring determinations. They're just non-job related. So we have to be careful of both the conscious and the unconscious bias that we attach to those sorts of things. So our management tips. A BFOQ exception is narrowly available. So if we can be very clear that someone of a particular ethnic group is absolutely essential for doing the job, we can make that case. But it is fairly narrow. Employees can file national origin discrimination claims even if they have been simply perceived to be of national particular origin. This same concept holds for ADA, right? Even if someone perceives you to be disabled, you would still be protected under ADA. So even someone perceives you to be or assumes that you are from a different country, have a different national origin, different ethnic background, um, even if that may not be true, but if they perceive it to be, then that would be a violation. English fluency may be required, but beware of accent-based discrimination. We want to tailor our language-based rules to the setting. So we want to make sure that the language is really essential for that job, and the level of clarity has to be clear. Accent discrimination is not okay. It is considered illegal, but we also want to make sure that it's about fluency of how we communicate and fluency of the language that we use. Customer, client, or coworker preference or comfort or discomfort is not a source of a BFOQ. So if you have customers that say, I don't really like dealing with that person from India, I don't understand them, it doesn't matter. You can't fire them for that reason. And you certainly cannot treat them inappropriately and not give them job opportunities because of that. Federal contractors also must follow the guidelines on discrimination because of religion and national origin, and so they're held to that high standard. Before instituting a policy, consider the implication of Title VII and in the Immigration Reform Control Act because they do complement each other, and IRCA fills that gap, as we talked about, between what is considered the threshold number of employees you need to be required to do Title VII and apply Title VII to your workplace, and whether or not we can discriminate based on citizenship and things like that. We want to recognize that there are some concerns in the post 9/11 era about Middle Eastern employees who are being discriminated against and stereotyped just because they happen to be from the Middle East. And we want to make sure that the conflict and climate is going to continue to drive migration from Central and South America. More Latinx workers will be joining the U.S. workforce. And this has implications for diversity and inclusion because we know that Latinx workers are the fastest growing population in our workforce. And so migration is going to happen. And so how can we manage migration rules and have policies in place that helps people to be able to do work at reasonable rates and reasonable pay and not be taken advantage of?